So what happens after a federal rearraignment or plea setting? After you've entered a plea of guilty in federal court, your case is referred to the United States Probation Department. A federal probation officer will set an appointment to meet with you and conduct a pre-sentence investigation interview. During that interview, probation will ask you a lot of questions about yourself, your background, your childhood, any drug or alcohol use or abuse. They won't ask you many questions about the underlying offense. Typically, the attorney will have told probation that you are going to, quote, stand on the factual resume. What that means is you have already agreed to a certain set of facts and you still agree with them. You're just not commenting more, nor are you inviting more questions about the underlying offense. That way, you will get your acceptance of responsibility, which will be potentially a 3-level decrease in your sentencing guidelines without risking saying something that could maybe affect your ability to get that reduction or make matters worse. Probation will ask for a number of releases. They'll want to know things like your educational background and get those records, your medical history and get those records. If you've been in the military, they'll want your military service records. So there are a number of things that they're going to ask you for releases for so that they can go out and get that information. Probation will also ask for the name of a person, ideally within your family, that can verify some of the information that you share with them. Handled correctly, the pre-sentence report interview is an opportunity for you to get information to the judge. So be sure that you talk to your attorney about every aspect of the pre-sentence investigation interview before you go into that interview. Once the pre-sentence report is prepared, your attorney will generally have 14 days to file any objections to the pre-sentence report. 35 days after the pre-sentence report is issued, the judge will have a deadline for you to turn in your sentencing materials. Your attorney will submit a number of things on your behalf. For example, there might be a motion for downward variance or downward departure. You will almost certainly have a sentencing memoranda that's filed on your behalf by your attorney. You will have character letters that are submitted, written by folks who know you and have compelling things that they want the judge to consider. You might have photos and videos that your attorney submits to the judge so that the judge consider all of these things in crafting your sentence. You will ultimately be set for sentencing. Your sentencing date will be a function of how busy the court is, but it's generally a few months after the rearraignment or the date that you entered the plea. After sentencing, you have 14 days to file your notice of appeal. That's not the actual appeal, it's just providing the court with notice that you intend on appealing. There are very critical deadlines in federal criminal cases. If you're facing a federal criminal charge, be sure you find an experienced federal criminal defense attorney. This video was made in response to a question we received on this channel. If you have a question about criminal law in Texas or federal criminal law, drop a comment below and we'll be sure to answer that. You can also check us out at versestexas.com.